All righty, everybody. I think we're going to get going. I'm Vikram Amar, and I'm the Dean of the College of Law, and it's great to see all of you, and thanks for being with us. We have a large group today. We have probably over 100 after everyone jumps in. So the first thing, if I might ask everybody to turn on their mute so that we don't hear any stray sounds or feedback. And my plan is to talk for about half an hour and then answer people's questions. But rather than have people offer their questions orally, if at all possible, you put your questions in the chat box. So on the bottom, you'll see a row. A chat is one of the icons on the bottom. If you click on that, you can type in a message that will go to everybody. And then I'll keep an eye on the chat box, and Bill Turner will help me in that regard. And then we can answer questions. I really want to talk about things that you all want to hear about. So certainly when we get to the question and answer part, feel free to ask about anything that's on your mind these days related to the Supreme Court, lower courts, the election, how the election affects the courts, how the courts affect the election, et cetera. But before, just to get the ball rolling, I thought I'd start about talking about a couple of topics. One is the confirmation process that we just went through, resulting, of course, in the addition of Justice Barrett to the Supreme Court. And then I thought I'd talk a little bit about, the topic of court packing, broadly understood, that's getting a lot of play in the media and on the campaign trails and in the debates. So let's start with the confirmation process. I come at this actually from two different starting points. And I've written about the confirmation process in the US Senate for almost 25 years. I probably have written as much about the United States Senate on the legal constitutional side as most any other scholar that I can think of. My student note at Yale when I was in law school was about the US Senate, and a good chunk of it was about the confirmation process even then, right around 1990. And I wrote a big article just about a decade ago on the flaws with the confirmation process. So I look at it, as I say, from two kind of vantage points. One is, are we using a process that helps us get the best justices, and that helps the Senate and the president make a decision about whether this person that they're putting on the court really will move the country in the right constitutional direction or the wrong constitutional direction. So vantage point number one is this a good way to vet justices? Is this a good job search interview process? And the other vantage point is this a wasted opportunity to really educate Americans about civics in a way that they so desperately need? There's just no denying that Americans really stink when it comes to civics and their understanding of government. The average person can name more dwarves from the seven dwarves than they can Supreme Court justices. That's not an exaggeration. Poll after poll shows that. And I'm not going to kind of get into any joke comparing those two groups. But if I see it every day, every year. If you compare the students who come into great law schools like the College of Law today compared to the mid-90s when I started teaching, they know much less about American history. They know much less about American government. Our civics education in K through 12 has just really failed us. And so too have our elected leaders. And so I really look for opportunities to kind of cheaply and efficiently educate the American people about the way government does or ought to work. And confirmation hearings are actually one tremendously big and missed opportunity to do that. It's not the only opportunity. There is no reason on earth why the Supreme Court shouldn't and doesn't televise its oral arguments. Obviously, we're in an unusual moment with COVID, and there are no actual oral arguments. It's all done telephonically, but forget all that. There's no reason why they can't at least televise them and record them and show them later if they don't want to live stream. But they're live streaming the telephonic arguments now, presumably because that's the only way there can be any public monitoring of what's going on. They used to, in essence, rely on the 100 or so people who sat in the courtroom, and they're trying to replicate that by at least allowing people to listen in real time. And there's been a handful of other instances where the court has streamed audio real time. But you're not going to engage young people with audio, with these disembodied voices of these oralists. They want to see the scene. They want to see the drama, the human drama. And as I say, lower courts do it, state Supreme Courts do it. Congress has done it for forever. Do you think C-SPAN has degraded the quality of discourse in Congress since the 1970s? No, there's lots of things that have degraded the discourse in Congress since the 1970s, but C-SPAN and Brian Lamb are not two of them. That's been a tremendous resource for America, for people who want to see how things work. So again, I don't want to pick on the Senate in the confirmation hearings as the only opportunity to do a better job for government to participate in this educational enterprise, but it certainly is one. And why has it failed so miserably? For one big reason, and for this same reason, it fails at the other task, that is it a good process for deciding whether to approve someone to serve on the court? And the failures are so epic on both of these dimensions. It doesn't help anybody on the Senate really make a good decision, and it doesn't help Americans understand what's at stake here. The reason it fails so miserably on both axes, to the point where I can't even stomach watching them. I couldn't watch the Amy Coney Barrett hearings. This is my life. I write about this stuff. I work on it. I can't. It's too depressing. It's too stupid to endure. And so I'm at the point where unless it's going to get better, it's not even worth having. It's almost counterproductive to have this kabuki theater. There's no government or law to it. One of my fellow deans asked me, what I thought of the hearings, and then he thought better of it, and he said, well, maybe I should ask the College of Media dean what she thought of the hearings, because it's all about spin and FaceTime and presentation. And then I said, no, it's not. The College of Media is not the relevant person. It's the Dean of College of Fine Arts, because this is just theatrics. This is just, it's literally kabuki. And the big reason for all of this is the nominees don't answer any of the questions that are perfectly fair to ask and that should be answered. And the senators let them get away with it. And the senators let them get away with it on both sides of the aisle. It's the Republican senators and the Democratic senators. They let Ruth Bader Ginsburg and Elena Kagan and Sonia Sotomayor get away with it, just like they let Neil Gorsuch and Brett Kavanaugh and Amy Coney Barrett get away with it. Forget the second part of the Kavanaugh hearings about Christine Blasey Ford. That was a total separate thing. Let's just focus on the first part of the Kavanaugh hearings, which was the substantive part. Nobody answers the right questions, and the Senate lets them get away with it. Now, why does the Senate let them get away with it? I think there's a lot of answers to that. Most of these senators aren't particularly skilled lawyers. Some of them are, but most of them are not. Some of them aren't even lawyers at all. I mean, how do you have the ranking member of the Judiciary Committee on the Democratic side, Dianne Feinstein, who's not a lawyer, and really, I like Dianne Feinstein. I come from California. I voted for her many times. She's not even really understanding the script that her staff is giving that she reads. It's like a lawyer doing an examination, a cross-examination, and not being able to really understand the questions that they're asking. How are you going to ask a good follow-up question if you're really not fully appreciating what the nature of the enterprise is? I think the senators on both sides of the aisle agree to just play this little game because it serves their political purposes. Maybe they don't want to get a better sense of what the people really believe, the nominees really believe. And why is that? Because their votes are already predetermined in today's age. There's nothing anybody could say to any senator in the last 10 years that would basically change their mind. They're going to vote up or down based on a lot of things that have nothing to do with whether this person has got a good grasp of the right direction in which constitutional interpretation ought to move. So what are the questions that should be answered that aren't being answered? Well, the questions are as follows. Dear nominee, dear candidate, which set of writings in the following 5 opinions handed down over the last 10 years did you find persuasive or unpersuasive? In Shelby County versus Holder, the case that gutted the Voting Rights Act, did you think Chief Justice John Roberts' opinion was persuasive? Or did you think that Ruth Bader Ginsburg's dissent was persuasive, and why? If I couldn't ask my students come exam time to talk about the specifics of the cases that they've read, why give an exam? You can't get any answers without specific questions. Why is that? Because if you ask questions, do you believe in text? Do you believe in stare decisis and precedent? Do you believe in looking at the history that surrounds the enactment? Everybody agrees with those principles. Everybody is a textualist at some level. Everybody takes precedent into account at some level. Everybody is an historian at some level. As Elena Kagan said at her confirmation hearing, we are all originalists. So I'll put the point to you in the following terms. When William Brennan and Nino Scalia answer the same question the same way, that question isn't giving any useful information to anybody. If both of those people can in good conscience answer this question the same way, that's a worthless question. The only way to get to know what kind of jurist somebody is to ask them which opinions they agree with and which ones they don't. Now, what do the nominees say when they refuse to answer that? Well, they say, I can't answer that, Senator, because that involves an issue that may come back up before the court. And it would be kind of a violation of judicial ethics, if you will, for me to weigh in on something that may come before me as a justice. Really? If that answer were plausible, then why can any of the 9 justices who've already written about these issues in past cases, why are they allowed to hear new cases about those issues going forward? There's no good answer to that. There is a difference between an open mind and an empty mind. What the nominee can say is, Senator, I cannot promise how I would rule. I cannot say with any certainty what I would do if I were on the court and this same issue came back, but I can tell you what I thought of it when I looked at it, when I read the opinions. I would obviously read additional briefs. I'd be open to persuasion, open to arguments, etc. The justices, when they get case after case after case involving the same kinds of issues, they're allowed to take those cases, not because their minds are empty, but because at least nominally they haven't locked in, they're not committed to any particular course of action. They can always revisit their priors and do what they think is right with the benefit of new briefing, new discussion, new argumentation, new facts on the ground, etc. Ironically, the Supreme Court itself recognized all of this in a case about 20 years ago out of the state of Minnesota called the Republican Party of Minnesota versus White. Maybe it was 15 years ago. In Minnesota, judges run for election. They're not appointed the way federal judges here are in the United States. Minnesota passed a law that said candidates who are running for judicial office cannot pledge how they would vote on particular cases. That's easy. That violates due process if the judge before whom you are appearing has already promised to do something other than decide on the facts and the law as they're argued. But this Minnesota law went further, and it said no candidate for judicial office running for election can comment on any legal issue of the day. And the idea was we want judges not to be, shooting their mouths off about various topics because that undermines public confidence in judging, and people think that people are locked in, et cetera. And the U.S. Supreme Court struck that down as a violation of the First Amendment by a 5-4 vote, with Justice Scalia writing the opinion. And what Justice Scalia said is spot on. He said, if you can't talk about the legal issues of the day because they might come in front of the court, then what can you talk about? He made the same point I did. Platitudes about how I'm faithful to stare decisis in past cases, and I take text seriously, and I look at the original understanding, and I look at the effect a ruling has on people. Those things mean nothing until you apply them to a particular issue of the day. Let me read to you what he said. Scalia explained in White, like most other philosophical generalities, general statements of your approach to judging have little meaningful content for the electorate unless they are exemplified by application to a particular issue of construction likely to come before a court. For example, whether a particular statute runs afoul of any provision of the Constitution. So if you can't give your tentative views about whether you think a particular statute that's out there violates the Constitution or not, then you're not giving any information for the voters or in the federal system for the senators. So the distinction that matters is not between general philosophy, which is okay to talk about, and specific cases, which are out of bounds. That's a stupid distinction. The distinction that matters is between a prediction and a promise or a pledge. I cannot make any promise or pledge to you, although I can tell you what I currently think about this issue. And if senators confronted nominees with this easy kind of rejoinder, and they said, you say you can't talk about this because it may come before the court, well, then why can current justices talk about it in their opinions when it comes before the court again? Why can justices give speeches and write law review articles? Why is it that you're willing to talk about some cases but not others when anything could come before you? Because they all slip up, because they get tired of saying, I can't answer that, I can't answer that. So they do, when they think a case is safe to talk about because it's not going to engender much controversy, they do share their views on it. But that opens the door, that concedes their entire defense. Why can you talk about this case, but not that other case? And if the answer is, well, that other case might likely come before me again, whereas this case involves settled law, then the rejoinder is, there ain't nothing settled law in today's world. There ain't nothing that over the course of a 40-year career on the Supreme Court, which is what we're looking at for people who are appointed in their 40s or early 50s, there ain't nothing that you can say with any certainty is not likely to ever come before me down the road. So there really is no good answer to not being able to ask these questions. Now, we could get into a detailed conversation about which are the 5 or 10 bellwether decisions in the past 20 years that I think would be the most helpful to seek someone's views on. In other words, if you asked me, if I really want to know what kind of justice someone is likely to make, which are the 10 cases that I want to know what they think about, I could give you my 10 and why. And I could explain why agreement with the majority, the concurrence, or the dissent in those 10 cases tells me a lot about the kind of originalist someone is, or tells me a lot about the kind of living constitutionalist someone is. Those are vacuous phrases unless you apply them to cases, and you want to apply them to the right cases. Now, of course, a nominee might honestly answer, as students do in my class, when I ask them about a case, they may say, I don't really know enough about that case, or I haven't really thought about it. I haven't looked at the briefs. I haven't read those opinions in a while. So what do you say if that was the answer? Okay, nominee, I get that. Tell you what, after the hearing, I'm going to give you 2 weeks, and I'd like you to write a 5-page written answer, take-home exam, if you will, answering this question. I'm not going to put you on the spot. I understand you might not want to answer without being able to look over the opinions again. I'll give you the time to do that, but you can't avoid answering my question. You can at best defer. Just like when I call someone in class and they say, I'm not prepared, I say, all right, tomorrow, be prepared, and we'll pass on you today. So there's a lot of techniques. I mean, done properly, a Senate confirmation hearing should be like a good seminar in law school. It should be substantive, it should be specific, and if people aren't ready to share their views at the moment, there are other ways of making sure that they don't wriggle out of it over the course of the seminar. All right. So that's a little bit about the confirmation process, which is so broken as to, I don't know if it can be fixed. It's like so much of the rest of democracy and stuff on the Hill. I don't know what the answer is. Now let me pull the lens back a little bit. Sure. Actually, the 10 cases that I would choose, 6, 7, or 8 of them are in the article that Heather distributed to you that really goes into all of this in much more detail. Now, that article was written 10 years ago, so there are 3 more cases that I might add since then. And the 3 cases in the last decade that are really important to give a clue about what someone believes are the first big Obamacare case, National Federation of Independent Business versus Sebelius. The Voting Rights Act case that I just mentioned, that's Holder versus Shelby County. And then a third one might be for me, it might be the affirmative action case out of University of Texas called Fisher versus University of Texas 4 years ago. And there are others that I might consider in the last decade as well. Perhaps the same-sex marriage case, Obergefell, is a very big one, and an opinion that Ruth Bader Ginsburg wrote that is very important today because it really bears on post-election challenges to the outcome in various state contests. That's called the Arizona Legislature versus the Arizona Independent Redistricting Commission, AIRC. So those are 5 that I might add to my list that I have in the article, and maybe they would displace 3 of the 10 that I have, and maybe I'd bump up the size of my list to 12 from 10, because constitutional law always grows. Every 4 years I redo the case book that I co-author, and it always gets bigger and bigger because I need to add stuff, but there's very little stuff that I feel I want to cut. That's just the nature of the field of constitutional law. All right, so let me pull the lens back a little bit and talk about the bigger problems with the Supreme Court and various proposals to fix them. If I had to identify the major issues with the Supreme Court, they would be threefold. First, although lifetime tenure on the court, or as a judge at least, was intended to remove too much in the way of crass partisan politics from judging. The idea is if you don't have to worry about your job, you're free to vote your conscience. And so you don't have to think about politics. But it turns out that didn't really wring politics out of, and by politics, I don't mean policy, philosophy preferences. Everybody has different philosophies of judging. I'm talking about big R, capital D, Republican, Democrat, team blue, team red. We didn't want judges to be worried about whether they're part of team blue or team red. But it turns out that instead of eliminating partisan politics from judicial processes, we just telescope it down to 2 moments. The moment of appointment and the moment when you decide to retire from the court. So all the lower court judges who are on the Supreme Court now were lobbying to be on the Supreme Court for the entire time they were a lower court judge. And they were playing partisan games, not just conservative liberal games. They were playing Republican Democrat games to make sure that they didn't get excluded from shortlists. It's one of the reasons academics are less likely to become justices going forward, is because we speak our minds and we're not always careful to avoid irking the Democrats or the Republicans, or at least good academics are doing that. So, Amy Coney Barrett, and I'm not saying, this is not a criticism or Brett Kavanaugh, they were posturing when they were deciding lower court cases to make sure that they stayed on Republican presidential shortlists. So they're involved in politics. And then on the back end, nobody wants to step down and give a seat to a president of the opposing team. David Souter waited, and as soon as Barack Obama got elected, he gave the seat to Obama. If Joe Biden wins, you will see Steve Breyer retire within the first year, assuming the Dems have the Senate. And he won't want to wait till 2022 to risk the Dems losing the Senate if they win it next week. A lot of this is why a lot of us, myself included, we wrote publicly that Ruth Bader Ginsburg should have resigned in 2014 when Barack Obama was president and the Democrats had the Senate. Well before, they lost the Senate and they blocked Merrick Garland and all that. For a variety of reasons, she wasn't ready to retire. But I thought at the time, she's 82, she's got cancer. You never know when you're going to have a president of a like-minded constitutional philosophy in the Senate, and she should have. And a lot of people didn't want to, criticize a sitting justice for not doing that. And I get that. It's not very genteel. But in hindsight, a lot of people wish that she would have done that. And more people are at least being candid about that. So that's problem one. We're too much partisan politics at the front end and the back end. Problem number two is related to problem number one. And that is presidents never know whether they're going to get 0, 1, 2, 3, or more picks in a 4 or 8 year term as president. It's haphazard. It's random. People get sick and they die. And sometimes they die and give the seat to a president they didn't want to. When Scalia died, he didn't want to give his seat to Obama. And it turns out he ended up not giving it because the Senate blocked Merrick Garland. But it's happenstance how many seats a president gets. For that reason, the Supreme Court doesn't track or mirror presidential and senatorial election outcomes very well. We vote for presidents and senators in part based on the kind of justices that they would appoint and confirm. But because vacancies are so sporadic, there's a misalignment. So you have some presidents who get a lot of picks. I mean, Trump had 3 and 4 years. That's remarkable. Other justices, other presidents get 1 and 8 years. And that doesn't align with American democracy very well. And then the third point is, because of life tenure on the court, there's a tremendous incentive to pick justices who are not only tried and true and unlikely to disappoint. So the days of Harry Blackmun disappointing, Richard Nixon, or David Souter disappointing H.W. Bush, those are pretty much gone. You have some ideological drift. I mean, John Roberts is not as conservative as probably W wanted him to be, although W wasn't as conservative as some presidents have been. But you're not going to get a William Brennan appointed by a Republican president anymore. So you pick people who are known quantities, who have track records that they have cultivated over the years. Now, obviously, once they're freed up and on the Supreme Court, anything could happen. You could say, ha ha, fooled you all. Now I'm going to do what I really wanted to do all my life. Maybe, but it's hard to stay, kind of cabined from your true self for that long. But the other big problem is we not only pick people who have been lobbying for the court all this time, we pick people who are in their 40s or just about 50, rather than people who are in their late 50s or 60. And that may be, I would say, the peak, the right time, where people have the most experience and judgment, but they're still young and vibrant, and they still got 20 years to be very, very healthy and alert and engaged. I mean, at 55, I'd be a much better anything than at 45. Now, I don't know if that's going to be true at 85, but I've learned a lot in the last 10 years. And yet we pick Amy Coney Barrett at 47, we pick Brett Kavanaugh at 53, because we want them to serve for 40 years. And that may be great for your legacy, but it's not great for the court to have people who aren't quite as mature as they might be. Okay? So what do we do about this? Well, the crass kind of court packing, the FDR kind of court packing is not, to my mind, the answer. Even though, I wish the Republicans had given Merrick Garland a hearing. I do actually think that, I actually agree with Mitch McConnell that it's very different to block a nominee from a president of the opposing party than to not process one from a president of your own party. The reality is there's just not a lot. Look, the president and the Senate are both given a veto over Supreme Court appointments for a reason. It's a two-key system. Both entities have to turn their key to launch this nuclear missile that is a new person on the court. So there's nothing wrong with not turning your key when you don't agree with the other partner, but turning it when you think, yeah, this North Korea needs to be dealt with. We need to turn the key. So there's nothing hypocritical. It's just hardball to do what they did in Merrick Garland and then for Amy Coney Barrett. There was nothing, kind of illegal or unconstitutional about it. It's just very hardball. Court packing is hardball as well, but in a way that would, I fear, provoke tit for tat. There's no stopping point to court packing. You add 3 of your ilk, we'll add 4 of ours when we get the Senate and the president ourselves. And all of a sudden now the Senate looks, the Supreme Court looks like my faculty. And we got 30 people there. And it's a lot harder for me to manage 30 than it would be for John Roberts to manage 8 others. Okay? So court packing is a mutually assured destruction strategy with no good stopping point. By contrast, some of the other proposals that are out there that I think merit attention don't have that built-in tendency to escalate. Most interestingly, I am bullish on a proposal that my older brother, who's a law professor at Yale, first floated 20 years ago, although a lot of other people are talking about it today, and they'll sell it as their idea. But my brother was the first one to float this in an op-ed, and the idea is as follows: that when Article 3 talks about having your job for good behavior or so-called lifetime tenure, that is a reference not to being on any one court, but to being an Article 3 federal judge. So you don't have an entitlement to serve on any court for good behavior. You just have an entitlement to serve as a federal judge for good behavior. What that means is you can, by statute and without a constitutional amendment, rotate people off the Supreme Court after 18 years, or whatever term you pick, and create vacancies that are filled on a more regular basis to track presidential and Senate elections. So the idea would be the following: every president gets 2 picks over a 4-year term, 1 pick every 2 years. 2 times 9 is 18. So that means each justice serves for 18 years. 18 years is more than enough time to make your mark, to become kind of, to grow into the job, if you will. It would create incentive to people to pick people in their early 60s rather than in their late 40s, because you pick someone who's 63, 81's not old anymore. That's perfectly appropriate. And you would let the Senate and the president track each election cycle. So now there's a little bit of a transition issue. How do you ramp up and get to that without the court growing to an unruly large number? And that's some of the logistics that my brother and I and others are trying to work out. But this is a promising avenue that is basically what Joe Biden's talking about when he talks about this commission. When he talks about this commission, he's talking about not just people like my brother, but I think my brother in particular, perhaps, I hope. I don't know. I'm not privy to all the conversations, but he and a bunch of other people who are trying to kind of work out logistically how this might come about. And when it comes about, it needs to come about as a package of a lot of broader reforms to the way the federal courts and the Supreme Court operate. And we could descend into some of the details if people have questions. but I wanna leave at least 20 minutes to take up your thoughts. So so it's about 12:40 right now. So let me open up the chat box and anyone want to type something. And if you'd rather not type your question, if you just type hand or I have a question, then I'll recognize you and you can unmute yourself and just offer the question orally. So what's on people's minds 6 days before this election? You could also raise your hand in the participants box. You can check on that. If anyone wants to do that. All right, Tom Montgomery. I saw my brother said he recently reported in the New York Times. I think it's reasonable and sensible. Thank you for working on it. Thanks, Tom. So yes, yesterday, I don't know if it's yesterday that you're referring to, but yesterday, Steve Calabrese, who's a professor at Northwestern, one of my brother's best friends, although he's kind of on the other side of the aisle, if you will. Steve is kind of a Republican who is supporting Biden. He's a co-founder of the Federalist Society, and so he's conservative in his legal philosophy, but he's still supporting Biden. Steve Calabrese wrote up this idea that really came from my brother in New York Times yesterday. My brother and I and Neil Katyal actually had a separate op-ed in yesterday's New York Times that focused on the kind of resurgence of the resurrection of a really terrible case, Bush versus Gore, and one of the theories in it. And we're trying to kind of send a shot across the bow to people like Brett Kavanaugh that it would be terrible to try to take this flawed legal theory and run with it. Steve's piece in yesterday's New York Times does lay out some basic framework for this idea if you're interested in taking a look at that. And he's far from the only one. But there's Jason asks, can the system that proposed apply to current justices who already have a lifetime appointment? In other words, can the current justices be rotated off? I think the answer is yes. And the reason, again, is the current justices don't have an entitlement to serve for good behavior on the Supreme Court. They just have an entitlement to serve as federal judges for good behavior. So if you make them a senior justice and you rotate them off the Supreme Court, but you still give them duties to sit on lower court cases, or when there's a recusal on the Supreme Court, you tap them to step right in so you have a full complement of 9. I don't think that violates anything constitutionally speaking. Politically, it may be dicey to do that. So you may prefer an approach where for some period of years, you have a court that's bigger than 9 with each president adding 2. And then as people kind of naturally reach the end of their careers and rotate off, the rodent moves through the snake. So we have 9 justices now, and maybe you build up to a maximum of 15 or 16, and then it starts to come back down and settles back to 9. That's another way that it could go. But these are some of the kind of the logistical details that folks like my brother are working on. Okay. As to the first part of my presentation, if the nominees answer specific questions, won't you still be left with the untestable premise that the nominee still has an open mind? How would the Senate be able to prove that in more detail? Well, look, people can always lie. You can't prevent people from lying. But I tell you what, if I say I don't agree with the justices that have endorsed, at least have said affirmative action is permissible under the federal Constitution. If I were in a hearing, if a Republican president nominated me and senators were asking me, what do you think of this Fisher case from Texas? Do you think the 14th Amendment allows universities like your former university, University of Illinois, or your current university, if I were still here while I got nominated, or the University of Texas to take race into account? If I said I don't think the 14th Amendment allows that, Then you say, all right, well, then why did you say this in that article? And why did you say this in that lower court opinion? Why did you say this in that speech? And maybe my argument is, well, I've changed my mind. But it's not plausible if I've changed my mind about everything. I've had a complete conversion about everything. So I gotta say, the people who get nominated to the Supreme Court are generally honorable people. One of the reasons they don't want to answer these questions is because they don't want to lie. But if forced to answer, they're not going to tell you something that's blatantly inaccurate. They'll try to hedge, they'll try to cabin, they'll try to dilute, but they're going to give you a sense if you force them to. And here's what needs to happen: if senators on both sides of the aisle say, we have a pact. I like certain kinds of nominees with certain kinds of visions. My colleagues like other kinds of nominees with other kinds of visions. I get all that. But we are going to agree that neither of us is going to vote to confirm somebody who doesn't answer questions, right? I will vote to confirm you if you answer questions and I don't like some of them. I'll still be open to confirming you, but I will not confirm you if you don't answer my questions. I mean, part of the problem is, and this is linked to the fact that nobody will cross the aisle to vote for a candidate, a nominee of the other party anymore, right? You know, it wasn't so long ago where you had even very liberal or very conservative nominees. They got 60, 65, 70 votes because it wasn't just one block against the other. So this issue about the dysfunction of Senate questioning is nested in larger dysfunctions in the Senate where no one ever breaks party ranks. Mitt Romney was the first senator in United States history to vote to convict a president of his own party in impeachment. Partisanship is a huge thing. And when you have impeachments, it's usually likely to be a moment of high partisanship. And so that's why you never have people breaking ranks in times like these. But we got to get back to the place where you do have some kind of a center. But I'm not too worried about people actually lying. Maybe they'll exaggerate the extent to which they'll consider new arguments. But I got to tell you, there are a lot of justices who do say, over time, I've been convinced that a position that I rejected earlier is the right position now. And that's going to happen more when you go from a lower court to the Supreme Court, because as I say, you've been posturing and lobbying as a lower court judge. So you have a lot of room to maneuver without people accusing you of bad things. Okay, Andrew, let me see what you said. So I think Supreme Court justices will find any effort to remove them from the court unconstitutional. That's a good question, and it's a possibility. If ever there were a case for recusal, you'd think it would be where the justice's own job was at stake, right? If their own livelihood is what's at stake. I mean, if a lower court judge tried to hear a case involving whether they should be removed or impeached, let's say the House impeaches a lower court judge, a district court judge, and somebody brings suit in that district court saying there was a flaw with the impeachment proceedings, and assume that person has standing. You think the judge gets to sit on that involving his own impeachment, right? That's why when the president is on trial for impeachment, the vice president can't preside over that impeachment. There's a strong theme in the Constitution. You cannot be a judge of your own case, right? That's why the vice president doesn't get to preside. That's why the chief justice presides when the president or the vice president is being tried for impeachment. Notice, by the way, the Constitution doesn't say that when a vice president is impeached and on trial, he shall not preside over the Senate as an impeachment. But can you imagine, if they had impeached Mike Pence instead of, or in addition to Donald Trump, Pence presiding over his own impeachment? Of course, John Roberts would have had to preside over that one too. So, Andrew, you'd think that they would farm this out to lower courts to have the last word on, or just consider it a political question that's not justiciable. But who knows? And courts always have the power to decide whether they have the power, right? There's always jurisdiction to decide whether you have jurisdiction, as kind of mind-blowing as that is. All right, Joel, how are you, Joel? Good to see you, my friend. What is the Supreme Court's authority in a presidential election? Is it limited to interpreting the voting laws of the states? Well, actually, the Supreme Court's authority in these elections is decidedly not to interpret the voting laws of the states, because that's state law, and state courts are the master of state law. If the federal courts think that a mistake of state law has been made, there is a device for that. They certify that question to the state Supreme Court. But the state Supreme Court is the last and expert word on state law, not the US Supreme Court. That's why the Bush versus Gore theory is so bogus. There are two reasons why it's bogus. And let me just lay out the Bush versus Gore theory. Article 1 and Article 2 of the Constitution say that the legislature of each state gets to set up the rules for congressional and presidential elections in that state. And if state courts interpret the state constitution in a way that conflicts with the laws that the legislature of the state has passed, 3 justices in Bush versus Gore said, well, that's a problem because the Constitution gives the power to the state legislature, not to the state courts. Now, as it turns out, the term legislature doesn't refer to the elected legislature of the state. It refers to the state's lawmaking processes more generally. So if a state wants to have a state court that enforces its own state, the state legislatures are the creatures of the state constitutions themselves. They're not empowered to do things that are inconsistent with the state constitution. So the first and big problem is legislature doesn't mean what you think it means. And that's what the Supreme Court held in the case I mentioned, the Arizona districting case from 5 years ago that Ruth Bader Ginsburg wrote, one of her best opinions. There they rejected the Bush versus Gore theory. Legislature refers to lawmaking process of the state, which includes the governor, which includes the courts, and which includes fidelity to the state constitution. So the first mistake they make is fundamentally that they think legislature means something it doesn't. But then the second mistake they make is, okay, if they think the state court is violating the will of the state legislature, even though the state legislature gave the state courts jurisdiction to hear cases involving statutes and constitutional provisions of the state, right? The state legislatures have themselves deputized the courts to oversee disputes for elections. If you think the state courts are botching questions of state law in a way that disrespects the state legislature, that's for the state courts to decide, not for you. Then you certify it to the state Supreme Court. If you think a trial court in Wisconsin gets it wrong, go to the Wisconsin Supreme Court. Don't yourself say what Wisconsin law means. Federal courts don't know anything about state law, which is why in Erie cases, federal courts apply the law of the state as determined by the courts of the state. And that's why you have the certification device. If you're interested in this at all, go to justia.com, justia.com. I have a 4,000-word essay on this posted just today that goes into great detail on this excellent question that you asked, Joel. All right, George Clark. What do I think of removing cert jurisdiction from the court and giving it to a rotating panel of circuit judges to prevent the recent practice by Alito and others of saying, bring me this type of case so I can rule on it? I haven't given any thought to this particular device, so I wouldn't want to weigh in on it. I think in general, the move away from regulating the Supreme Court's docket by requiring it to take certain cases is a good thing. So eliminating the right of appeal and creating cert, I think, and moving more things into the cert category was definitely a good move. Whether you want to take out things out of the cert category and basically jurisdiction strip, that's the term of art that would be used to take certain kinds of cases away from certain kinds of federal courts. I'd need to see a lot more specifics before I opined on that. Len, hi Len. If I'm not mistaken, the Ninth Circuit has 27 judges. I think it had a high of 29 or something. Maybe 27 is right. Why not have that many on the Supreme Court with shifting panels? Would take away the political weight of adding any one new judge. For the simple reason that the Ninth Circuit is dysfunctional, my friend. You have 3 judge panels that issue conflicting rulings all the time. And you can't go en banc and have all 27 hear a case because 27 is an unruly group. So year after year, there is a move to split the Ninth Circuit because 27 is too big. And the only reason that it fails is because we don't know how to split it without implicating a lot of politics. But if we could have split it before it ever got too big, everybody, Republicans and Democrats, would have agreed this is an unruly, unwieldy, large group of judges. And I don't think anyone invokes the Ninth Circuit as kind of an example of a well-functioning court, administratively speaking. All right. Could there have been a court challenge by Obama to force the hearing Garland? There can always be a court challenge. Like people say, well, couldn't you argue X? You can always argue X. The question is whether it would be a good argument. And this would have been a frivolous challenge. Constitution says the Senate shall have the power to confirm justices, not the duty. You don't have to hold a hearing. You don't have to take a vote. If you do hold a hearing, it's just like impeachment. The House impeached. The Senate didn't have to take up the impeachment case if it didn't want to. Mitch McConnell was right about that. Now, there was a Senate rule that said they should take it up, but a simple majority of the Senate could always have gotten rid of that rule. There's no legal obligation, just as there's no legal obligation for the president to nominate, to fill a vacancy, right? If Trump had wanted to, when RBG died, he could have said, I could nominate somebody, but I'm not going to. There's no duty to do anything. There is just a power to do something. And the Senate can exercise that power or choose not to exercise that power. All right, Fayaz Hussein, to everyone. I agree with you on most of what I've said. However, my disagreement must suggest that older appointees may be better for various reasons. Taking a page out of corporate America, a lot of C-suite executives ascend to the highest positions in their 40s, early 50s, when in my humble opinion, person is generally at their mental peak. Look, different jobs require different skill sets and different level of stamina. I'm here to tell you, it's a hell of a lot more taxing to be a dean than to be a Supreme Court justice. It's not, they decide 70 cases a year. They have clerks to help them. It's a pretty leisurely job. I clerked at the Supreme Court. I know what it's like there. We decided twice as many cases when I was there at the court. The court decided, I didn't decide anything. The court decided 150 cases a year back then. They decide 75 now. You know, when I clerked, Justice Brennan was in his 80s. Justice Blackmun was in his 80s. Justice Marshall was in his 80s. And Brennan was as sharp as ever. Justice Blackmun was as sharp as ever. You could fault these guys for their flaws, but the reality is, I'm not saying every 63-year-old would be a great person to have, but there are hundreds, thousands of 63-year-olds who have what it takes. And why exclude them from the pool the way the current system effectively does? Because you want your justice to serve, 40 years rather than 25. All right. Bill, if Democrats were to expand to 13 judges, what's to stop the Republicans from lowering the number of seats 9 somewhere down the line? They could, but they're more likely to increase it to 15 or 16 because unless they try to get rid of some of those 13, they're stuck with a court that they don't like in the meanwhile. So, and if they lower it to 9 by attrition, the older justices are the more conservative ones. Other than Breyer, the next oldest justices are all the Republicans. They're Thomas, they're Alito. Those are the next 2 in line. And even Roberts is older than Kagan. I guess Sotomayor and Roberts are probably about the same age. All right. First part of my presentation in this day of access to all opinions. Why is it that I believe there's a gap in understanding of justice and thought process? As I wrote, asking I'm not sure I quite understand the question. As the first part of it, in this day, all access to all opinions, legal writings, lectures, etc. Why is it I believe there's a gap in understanding of justice and thought process? I don't think that there's a gap in understanding. There's a gap in public understanding because no member of the public is going to read Amy Coney Barrett's Seventh Circuit opinions or her law review articles, okay? Whereas they will tune in on TV to watch this high drama. So if you can sprinkle in some vegetables into that bag of French fries that is a hearing, then they're forced to consume it. Of course, anybody who wants to, I know what all these lower court judges are about. I know what every nominee is about by looking at their writings, but that's because it's my job, it's my living, it's my life. But that's not true for 300 million Americans. And this is a missed opportunity to make that easier. Okay. Why would we need to make changes to the current process, flawed as it may be, unless unqualified and less qualified judges have been appointed? Because qualifications aren't the only thing that matters. You know, there are thousands of people who went to good law schools, who are, you know, smart people, who have good distinguished legal careers. You want to pick people who are going to move the court in the direction that you think is constitutionally attractive. And to do that, you need to know more about their particular views. I'm sorry, I got a call that I probably should take, and we're at the end of the hour anyway. So I want to thank, and that was the last question. So I think this all works out well. Thank you all so much for being part of this. As I say, look at the article that Heather distributed if you're more interested in the hearing process. If you're more interested on challenges to the election in the next couple of weeks based on what state courts and state administrative agencies are doing, look at the article on justia.com, or a shortened version of the same ideas in the New York Times yesterday that I and my brother and Neil Katyal, who's a law professor at Georgetown and who was acting Solicitor General under Obama and has argued about 50 cases in front of the Supreme Court, the op-ed that we wrote. And stay healthy. I hope I can see all of you again in person before too long. I miss all of you that I have gotten a chance to get to know in person. Stan, we will Zoom and you will educate me the way you've been trying to for several months now. Andrew, I hope you're teaching in the building in the spring, and I'll be in person teaching. So if you're in person teaching, maybe I can see you in person as well. And the rest of you, thank you for all you do for the College of Law, for the profession, and the larger society. I recognize that, you know, not everything I say is right, and lots of people have reasonable grounds for disagreement, but I just want us to be in more meaningful, substantive conversation about things than I think we've been in the last decade or two. Okay. Thank you so much. Take care, everybody. And thank you, Heather and Bill. Heather, I'm sorry you couldn't be heard, but you are definitely appreciated. Bye-bye.
Bye.